Our next speaker is Judge Schmaltz, Christiane Schmaltz, judge at the Federal Court of Justice of Germany. She has worked at the German Constitutional Court earlier in her career. She's been serving as Germany's ad hoc judge at the European Court of Human Rights for the last 8 years, and the floor is yours, Christiane.
Thank you very much, distinguished members of the Constitutional Court, Mr. President, ladies and gentlemen. The Federal Constitutional Court of Germany has dealt with constitutional complaints since the early 50s, so it's a rather experienced court, I guess. I will spare you the details of the constitutional complaint procedure because also it's actually pretty similar to the Slovenian model that we've already heard on. What I want to do is I want to focus on some practical issues and the question of effectiveness. And in this regard, let me point out just a few issues that contributed to what I believe is, at least overall, one could say, quite a success story of the German Constitutional Court as regards the constitutional complaint procedure. I believe these issues are also responsible for the rather strong position that the Constitutional Court of Germany enjoys in the constitutional landscape of Germany. I first want to focus on the competences of Constitutional Court. I believe that we can identify three core or pivotal, very strong competences that a Constitutional Court should have, and if it doesn't have it, I think it might always have the danger of being what one could call a toothless tiger. I think these three core competences are, first of all, the competence to quash judgments of the lower courts. The second competence is to declare an underlying act of the legislature null and void, and then the competence to issue preliminary injunctions, which is, I think, also pretty important. I think these core competences are even more important than the erga omnes effect that the decisions of the Constitutional Court should, in my opinion, also enjoy. The German Federal Constitutional Court has all these three competences. It regularly quashes the judgments of the lower court if it finds a constitutional violation of the Constitution, and it refers them back to the competent court. So the Constitutional Court, also like the Slovenian model, does not decide itself in the case, but it refers the case back to the court. And the lower courts then do not have an issue with res judicata because the judgment is actually reversed, so it's quashed, it's no longer there. In concrete norm control proceedings, also in other proceedings, and also in individual application proceedings, the court can also declare an act of Parliament null and void. Of course, this is always an encroachment of the separation of powers, but it is the function of the Constitutional Court, and the Constitutional Court in Germany in this regard sees itself as the guardian of the Constitution. The Constitutional Court, when it quashes, when it declares an act of Parliament null and void, it usually sets a time limit for Parliament to amend the law, and usually Parliament abides by these time limits. And these competences have in Germany led to a very strong position of the Constitutional Court. With regard to the relationship between the Constitutional Court in Karlsruhe vis-à-vis the European Court of Human Rights in Strasbourg, at the beginning, it wasn't really difficult because there were not very many violation judgments issued against Germany. But once the violation judgments picked up, the Constitutional Court and also the other courts in Germany were not really amused, one could probably say. And it also posed a methodological challenge to the German system because the European Convention on Human Rights ranks in Germany below our constitution. So the Constitutional Court sort of had to incorporate the convention and the case law of the Strasbourg Court into its case law, always sort of trying not to give it a constitutional status because it doesn't have that. But today the court consistently holds that the guarantees of the convention influence the interpretation of fundamental rights and constitutional principles of the basic law. However, I think it's only around since 2008 that the Federal Constitutional Court in Germany actually consistently and explicitly refers to the convention and the Strasbourg Court's case law in its judgments and decisions. Before that, it basically only referred to the convention and the case law in its internal drafts. So in the end, I believe that the struggles between Karlsruhe and Strasbourg, maybe they're not completely over, but I think we are in much calmer waters than with regard to the court in Luxembourg. And so in the end, this has led to a pretty high degree of harmonization of convention rights and the fundamental rights of the basic law. Also, the Federal Court of the Constitutional Court acts as sort of like an executor of the Strasbourg Court's case law, because with its cassation power regarding legislature as well as court decisions, it has at its disposal a very effective instruments for the implementation of the European Convention on Human Rights and also the Strasbourg Court's case law. And also with its judgments and decisions, it acts as an interpreter and translator of the judgments from Strasbourg for the lower courts. Regarding the relationship between the Constitutional Court and lower courts, they have not always been harmonious. At the very beginning, of course, the Federal Court of Justice, where I come from, in the early 1950s, wasn't really amused when the Constitutional Court quashed judgments of this high federal court. But the lower courts have accepted that the Constitutional Court has the last word when it comes to the Constitution, and they have also accepted that when they provide good reasoning in their judgments, they come into a dialogue with the Constitutional Court and can try to convey their thoughts on the Convention to the Constitutional Court, which can then incorporate those thoughts in its decisions. And so actually, today I would think that, of course, there are some judgments and decisions of the Constitutional Court which spark criticism within the judiciary, but that's normal and that's useful, and I think that's healthy because it triggers a process of thinking and debating. And I think this success story, what I would call a success story within the relationship between the lower courts and the Constitutional Court, is partly, I think one can contribute to that partly to the really very well-reasoned decisions and judgments by the Constitutional Court, but also, and I think that's very important, that there's a large number of lower court judges and prosecutors who have spent 2 to 3 years at the Constitutional Court. I myself have spent 3.5 years at the Constitutional Court in Karlsruhe, and then have gone back to my home court. And I've sort of carried all the knowledge I had gathered there at the Constitutional Court back to my court. And so currently, there are 16 justices of the Constitutional Court, and each one of them has 4 full-time positions to fill with law clerks, and they usually stay for 2 to 3 years. So, keeping in mind that the Constitutional Court has been in action, so to say, since the beginning of the 1950s, and of course the number of clerks has increased. But there's a large number of sort of like an output of constitutionally educated lawyers, judges, and prosecutors who go back to their courts and bring back their knowledge of the Constitution and the inner workings of the Constitutional Court. And I think they have those former law clerks act as ambassadors and also multipliers for the Constitutional Court. There are, of course, challenges to the authority of the Constitutional Court. I said regarding the implementation by the lower courts, this is basically no issue anymore. But we've had, in the last year, we have had one case where a city ignored, basically, a preliminary ruling of the Constitutional Court. This has not yet become a regular practice, and I, of course, hope that it will not become a regular practice. So also in Germany, we do not have sort of like a monitoring system for the execution, because usually and so far it still works, and this assumption that public authorities abide by court rulings is still true, I would think one could say, for Germany. And let me just conclude with 2 words regarding filtering mechanisms, because of course also the German Constitutional Court has a pretty big caseload, nothing compared to the Constitutional Court in Turkey. And we have basically 2 filtering mechanisms. We have the General Register, where all kinds of submissions are registered, which at first you might not even see what they have to do with the Constitutional Court, but then also constitutional complaints which are clearly inadmissible, and the General Register writes a letter to the applicant telling that it's really basically there's no prospect of success. And only if the applicant then insists that this complaint should be registered as a constitutional complaint, then it is submitted to the chamber, to the responsible chamber. So that's one filtering mechanism. And the other one is that the Constitutional Court can decide not to accept a constitutional complaint for examination without providing reasons, and it can do so when if there's no constitutional significance, and if there's no real burden on the applicant. There is always a danger of abuse with these rather free admissibility criteria, I would say, and it wasn't until 1993 when this last admissibility criteria was introduced. They had already introduced it once in the early 1950s, but Parliament had abolished that again because it had seen that the Constitutional Court had made use of it too often. So they thought, no, it had given the Constitutional Court too much leeway in deciding not to accept constitutional complaints for examination. So it was not until 1993 that it was introduced again. And so if the constitutional significance criterion serves as an admissibility criterion, I think this term must be very clearly defined so as not to give the Constitutional Court too much leeway in deciding which cases it wants to decide, because there shouldn't be any cherry picking. These terms must be very clearly defined. Thank you very much.